Assalamu alaikum and welcome to Just Law on IQRA TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, on Just Law we normally discuss an area of law which is of interest to you, our viewers. Secondly, more importantly, Just Law is a live show. So whatever questions you have on any aspect of English law, please feel free to pick up the phone, give us a ring, and hopefully we will be able to advise you, guide you in relation to your queries. And on this show, we should be able to cover most aspects of English law, matters ranging from immigration matters, family law matters, criminal matters, personal injury matters. So whatever your questions are, which relate to English legal matters, please do give us a ring and we should be able to give you some guidance in relation to that. Just a couple of points before we get going. Obviously, it's a live show, so we're not able to look at any documents that you have before we're able to advise you. If it does transpire that we do need to look at your documents before we can advise further, then I will speak to you off air and arrange to look at your documents off air and then advise you appropriately. And just before we get going, obviously on a live show it's not really possible to take very detailed sort of instructions from callers, and again, if it transpires that I do need to look at these matters in greater detail, I need to speak to you at length off air, then again I'll give you my number and then ask you to give me a ring so we're able to look at those matters off air. Now, as always, we get a lot of calls on immigration matters, which is fantastic, and that's why the topic that we have for today is an immigration related topic. Over the last few weeks, we've discussed various aspects of immigration law, the sort of more popular matters which relate to sponsoring spouses to come to the United Kingdom, applying for their extensions of their visas, applying for indefinite leave, applying for nationality, etc. We've looked at that in a lot of detail over the last few months. Now, the other sort of area where we do get a number of queries really relates to the position of those people who have overstayed in the United Kingdom. And what we did last week is we looked at sort of in very general terms what those people who have overstayed in the United Kingdom, how they can regularize their visa, their status in the United Kingdom. So we talked about how, you know, if one marries a British national, one marries a European national, if there are children from the marriage, if one has lived in the UK for a considerable period of time, how there are various different routes which lead to one being able to gain some kind of legal status in the United Kingdom, even though before any such application they might have become overstayers in the United Kingdom. So we've looked at sort of how one becomes legal in the United Kingdom, and we took a broad brush approach. We looked at the number of different options available to people. Now, what I want to do today is look at, in particular, those people who want to regularize their stay based on children of the marriage or children from the partner's previous marriage, etc. How, on the basis of children, can somebody who has overstayed in the United Kingdom, how can they regularize their stay in the United Kingdom? And that's really what I want to look at today. The reason for that is in practice, as far as immigration lawyers are concerned, this is an area where you get a lot of queries. A lot of the work relates to spouse applications, etc. But another major area of concern for those who are in the UK without stay is the fact that they might have overstayed, and how, based on children of the marriage, etc., how they can regularize their stay. So it's a very topical, very important topic for a lot of our clients, and I want to take you through the various steps that you need to go through, the various rules which apply in terms of regularizing one's stay in the United Kingdom where there are children involved. Now, as with most immigration applications nowadays, before you can make a successful application, there are certain mandatory requirements which need to be fulfilled. A lot of these mandatory requirements are fairly straightforward, in the sense that obviously there is normally a fee to pay for these applications. There is a IHS surcharge, an immigration health surcharge, which a lot of people refer to as the NHS surcharge, etc. It's that to pay. There's correct forms that need to be filled in. There's photographs that need to be submitted, etc. So there are a number of mandatory requirements to get this kind of application up and running. But the key problem that applicants face with these applications is that there is a requirement to, if you want to make a valid application, there is a requirement that you must have an original passport. Now, that passport can be a valid passport where the expiry date still hasn't been reached, or it may well be an expired passport. But there is an absolute requirement where these kind of applications are made, that you must submit a passport with the application. Now, if it's the case that the Home Office already has a copy of the passport, then it's fine. The application can be submitted without a passport, because the Home Office already obviously has a passport. But the reason I flag this up is that this is what causes a lot of problems. Applicants, clients find that they, let's say for example, they are in a relationship, and from that relationship there is now a child, and the child is British. So that's all well and good. Potentially we have all the requirements requirements that can be met. The difficulty is this issue about there having to be an original passport which needs to be submitted. Now, it's important therefore that even though all the other requirements can be met, that effort is made, or there is focus on obtaining an original passport if one doesn't have that. So it may well be that an application has to be made to the relevant embassy in order for a passport to be obtained. So that's one of the mandatory requirements that the Home Office has. You must submit an original passport even though it might have expired. Now, the reason for emphasizing that is, if you don't submit an original passport, then even if your application is an application which meets all the other requirements, the Home Office will still not refuse the application, they will reject the application. Essentially, they won't even consider the application in detail. They will simply say, look, there are some mandatory requirements, you haven't met the mandatory requirements, and therefore we are refusing, or rejecting, I should say, your application. So it's essential that one obtains an original passport before submitting this kind of application, because without a passport you can't even get your application off the ground. We don't even get to the next stage of having the application considered by a caseworker. It fails at the initial stage. So the key point is one needs an original passport. Now, second point, and this is something that I touched upon, is that there is normally a fee to pay. These applications are generally quite expensive. An application for an overstayer who wants to regularize his or her stay in the United Kingdom based on a child would normally pay an application fee of £1,033. In addition to that, there is an NHS fee of £500. So straight away, before even taking into account any lawyers' fees, etc., one has to get together the sum of £1,533, which is the minimum that's required to get the application off to the Home Office. That covers the application fee, and then that covers the IHS fee. Just on the IHS fee, in December 2018, so in a month's time, or in about 6 weeks' time, the Home Office is proposing to increase the NHS fee. At the moment, with these applications for 2.5-year visas, the NHS fee which is payable is £500. What the Home Office wants to do is increase it to £1,000. So come December or January, if you're making this kind of application, you will have to pay an application fee of £1,033, and you will also pay an NHS fee of £1,000. So instead of it costing £1,533, which is the case at the moment, it will then go up to £2,033, which is a significant amount of money a significant expenditure for anybody who's in this position and having to make an application. Now, what's made worse in my situation is the fact that overstays obviously aren't able to work, and somebody who is unable to work is having to accumulate and then pay fees in the region of £2,033, which is difficult for most people, but for people who are not allowed to legally work, it's extremely difficult. So that's the sort of second practical obstacle that one faces when making this kind of application. One is there has to be an original passport, and the second is there's a considerable, significant fee that has to be paid to the Home Office to get your application up and running. If you're okay on those two fronts, there is a original passport, there is the funds available to get the application up and running, then you obviously at that stage meet the some of the essential requirements that need to be fulfilled to get your case validated and to the next step or to the next stage. Now, essentially, these applications where children are involved are based, in my experience, on either the person who's applying having parental responsibility for a child who is British. So it may well be, for example, that the person who's overstayed might have married a British national or might be in a relationship with a British national, and there is a child from that relationship, and the child acquires the nationality of the other parent, and the child therefore is British. So one example, one typical scenario is somebody who's overstayed, they want to make an application based on the fact that they have a child who is British. So that's one type of application that can be made. So again, the requirements in terms of the mandatory requirements, they're the same in terms of having to submit an original passport, having to pay fees of 1533 or 2033 from December 2018. But let's say one example where children are involved is to make an application based on the child who is British. So that's one typical example. Another example is where there isn't a child from the relationship, but the parties have been living together, and the partner has a child from a previous relationship. So it may well be that this is a second marriage for somebody. The person who's overstayed, they've married somebody, and it's a second marriage for that person, and from a previous marriage they have a child. So potentially an application can be made on that basis as well, on the basis that even though the person who is applying isn't the biological mother or father of the child, they are still exercising parental responsibility for that child. So one is where the child from the relationship is your own child. The other is that the child is not your own child, but it is a child from your partner's former relationship. But for that child, you are exercising parental responsibility. You are looking after that child in the same way that a parent would. So that's another application that is made based on children. The third sort of matter that you come across in practice is where the child was born in the United Kingdom. It's your own child born in the United Kingdom, but has now lived in the UK for 7 years. So the child isn't British, unlike the first two examples where there is a British child involved. In the third example, the child isn't British, but the child has lived in the United Kingdom for 7 years, and an application is to be made on that basis. So where there are children involved, there are a number of different scenarios which allow successful applications to be made, from there being a British child, there being a child who is from the partner's former relationship, so not the biological child, so the parent is not the biological parent, but nonetheless the parent is looking after the child as if he or she was the parent. And then the sort of last common scenario that you come across is where the child is not British at all, but the child has lived in the United Kingdom for 7 years. The child might have been born in the UK, might have been born abroad and come to the UK, but the child has now lived in the UK for 7 years. And the rules which govern each of these different circumstances are slightly different, and there are different things that one needs to demonstrate. And what I want to do is look at what the differences are in these cases, look at what it is in terms of evidence that needs to be submitted in order to qualify for a visa based on this, based on a British child, which is your child, based on a former partner's child who you're looking after, who's British, or based on the child who's not British but having lived in the UK for 7 years. There are different rules, or in reality the practice that the Home Office adopts for these cases is slightly different, and one needs to be careful in terms of how the requirements are fulfilled. So let's take the first example, a most common example, which is that from the relationship there is a child, and because the partner is British, the child is British as well. In practice, this is normally one of the easier cases that one deals with. Easier because in practice the Home Office seems to be making less inquiries for these type of cases. We'll look at that in greater detail after we've taken our next call. Hello, Assalamu alaikum.
Assalamu alaikum. My name is Salim.
Hi, Salim.
I'm due to apply my FLRM.
Okay.
Sorry, the settlement. I have completed my 5 years in February.
Okay.
I will be. Then I'm going to apply for the next application for the ILR.
Okay, all right.
I'm not sure what exactly the form I need.
Okay.
And what sort of type of documents I need to provide to the Home Office.
Okay, so at the moment, you know the visa that you have, are you on a spouse visa at the moment?
Yes, I am on the spouse visa at the moment.
Okay, and in which year did you come to the UK?
I came in 2009 as a student visa.
Okay, all right, okay.
I got married in 2012.
All right, okay, all right.
And then I'm continuing another 5 years process.
All right,
which is ending up in 2019 of February. Okay,
so when does your so you then went into the spouse visa in 2012, so you would have then received a 2.5-year visa, so that would have taken you up to about 2015 some stage, and you would have applied for an extension again, which would have been a 2.5-year visa granted to you again. So when does that visa expire?
In February 2019.
February 2019. When do you get your 10 years legal residence then in the UK? Is that later on, is it?
No, I haven't received the 10 years legal yet.
Yeah, so I know, initially you said you came to the UK in 2009 as a student. Have you then lived in the UK continuously after that?
My call has been revoked in 2012 as well, so I've been sent back to Bangladesh.
Oh, right, okay, so you came back again. All right, okay. So let's just look at the spouse application. So the spouse visa that you have, and you're going to be applying for indefinite leave. There are, in reality, 3 things that you need to focus on. It's really as simple as that when you apply for indefinite leave. So those 3 things are, first of all, the financial requirement, secondly, the English language requirement, and thirdly, the relationship requirement. In reality, they're the 3 things that you need to concentrate on. Obviously, where there's a problem in the marriage, then it's more difficult, and there are other things that you need to look at. But in a normal case, financial requirement has to be met, the English language requirement has to be met, and we need to be able to demonstrate the relationship. So on the first issue, which is the financial requirement, in the same way when you applied for a visa, when you applied for an extension, you had to meet the 18,600 requirement. It's the same requirement that you need to meet again. So you will need to show income in terms of employment letter, 6 months wage slips and 6 months bank statements. Is that going to be okay for you, or is that going to potentially cause any problems?
No, it should be okay for me.
Okay, so you can use your income, you can use your wife's income as well, and you have to meet the 18,600 requirement. That's the first thing you need to bear in mind. You will have to meet the 18,600 requirement. Second thing you need to bear in mind is the English language requirement, and there you will need to get a B1 certificate in English. Your English, mashallah, is perfect, so there's no problem getting that. Did you get a degree from the UK before, or?
I've done MBA from London Metropolitan University.
Right. So if you've done the MBA from London Met, you don't need to do a separate B1 test in English. That is sufficient as far as the English language requirement is concerned. However, you do need to do the Life in the UK test, which I'm sure won't be a problem for you. So that's finances, the English language, you've got the university certificate, and you'll do the Life in the UK test. Finally, like you did when you applied for the extension, you have to demonstrate that the relationship is ongoing, and the way they assess that is to look at your documents for the period 2016, 17 and 18. So whatever bills you've got, whatever letters you've got in your name, wife's name, joint names, that has to be submitted. So if you look at it in that way, that it's finances, English language and the relationship, they're the key areas that you need to focus on in order to make a successful settlement application in 2019. Does that answer your question, or have you got any queries?
Yeah, it does. I'm just a little bit worried about in 2012 my call has been revoked, and when I went to the Home Office to apply my spouse visa, so they hold my passport and they asked me to go Bangladesh and apply again. So which is I have done. I went back Bangladesh and then I applied again, and then I came back after 3 months.
Right. So on that, because you left the country and they granted you a visa to come back into the UK, they've also granted you an extension. That won't cause any problems as far as indefinite leave is concerned. That won't cause any problems whatsoever at all. There's no allegation of any, not dishonesty, but any allegation that you've used any certificates which you shouldn't have used. You know what's going around at the moment with TOEIC certificates which have been used by people where the Home Office alleges that the person never actually sat the test. They've used a proxy test taker. Is there any allegation like that in your case? No. Then you've got nothing to worry about. I mean, that's the only thing that's causing a problem at the moment with people who were previously here, as students, might have transferred into a spouse visa. What the Home Office seems to be doing is when they apply much later on for an extension or indefinite leave, the Home Office then says, oh, by the way, we've now found out that many years ago you obtained a certificate by deception, and we're going to not grant you your extension or indefinite leave because you're not a suitable person. But look, in your case, don't worry. If there's no allegations such as that, you've got nothing to worry about on that front at all.
Okay. So what's the form,
the form
I should have?
Yeah, sure. If you download the form SET-M, so it's S for sugar, SET, and then in brackets M, in brackets.
Okay.
So SET-M is the form. The fee at the moment is in the region of £2,400. There's no NHS fee to pay, but the fee is £2,400. If you want to use the premium service, you're able to use the premium service as well, for which there's an extra fee of approximately £600, where you can get a decision on the day.
Last time when I did the extension, I went myself, and they stopped me. I went for premium service. My wife was with me, and then I applied for everything, and I was expecting day by day will be sorted everything, but they hold everything for 6 months.
Why was that?
I received my papers back after 6 months.
Why was that? That's very unusual.
And now the same, like a ferry on me, that I'm thinking if I do the same thing by premium service again, I'm paying another £600 extra. And then I will get the same conditions again. They're going to hold me for another 6 months.
It's unusual, but I'm thinking if they did that last time, so whatever their concerns were, it seems that those concerns have now been cleared because they then ended up granting you an extension. So if you're not sure, and if you don't need a decision straight away, and you think it might be a waste of money, then just make a postal application. It normally comes back in about 4 months anyway. Okay. Brilliant. Thank you very much.
Thank you very much.
Thank you very much. Thank you. Thank you very much for your call. So just before we took the call, we were looking at how somebody who's overstayed in the United Kingdom, how based on children they can make an extension application. We're just going to take a short break. When we get back, we'll look at that in greater detail.